Hello, John Riley with the Legal Strike Force coming to you once again. Today I would like to complete the little series of presentations we've made on what is called by the insurance companies as examinations under oath. As I previously indicated, we'd be talking about some of the strategies involved in this, and I think it's always helpful for our clients and lawyers in our firm, and certainly others as well, to have an awareness of what it is that the insurance companies may be looking for, what strategies they may adopt, and what might be of interest to them when you are giving an examination under oath. And of course, what I say here today does not apply to each and every claim, but some general thoughts about different types of claims and what might be expected. We have now of counsel Michael McCary down in Philadelphia, Pennsylvania. He and I gave a seminar in Myrtle Beach, South Carolina, on the topic of examinations under oath, and Michael's very skilled in that. So for our friends in New Jersey and Pennsylvania and Delaware, Michael is a great resource right in the city of Philadelphia. And that having been said, I would like you to all also be aware that Michael and I have received a lot of literature and worked on a lot of things over the years in the nature of what insurance companies consider quote unquote red flags. And the red flags are things that they look for that might mean that there's some suspicion or something that needs closer scrutiny on a claim. And these can run from automobile claims to personal injury claims to arson claims to virtually any type of claim, including claims under death and disability policies, jewelry claims, and so forth. So we do have that capability and that understanding. But let me say that some of the things that an insurance company will look for as the claim is examined and might be brought up in an examination under oath would be, for example, similarities between your present claim and previous claims that you've made. Similarities range the whole gamut of things from having a water pipe burst each time you go on vacation to going to the same doctor with the same type of injury. And even beyond that, they may even look at the agent that you used and see whether that agent is producing business that leads to a significant number of similar claims, because sometimes agents are placed under scrutiny as well. The insurance company will also be aware of any recent economic conditions or trends, such as a poor economy in your state that might give someone an incentive to make a claim and turn to an insurance policy to try to make up for lost income, as it were. They would be certainly interested if there's any relationship between someone making a claim and a known fraud ring. Unfortunately, that sometimes transcends things into nationalities. There have been books written and pamphlets handed out about various types of fraud rings, people from certain areas of the world, certain countries. And again, Michael and I have gathered some of that information over the years, and it's probably still going on, even though we don't represent the insurance companies at the present time. Additionally, the attorney that you have can be part of the scrutiny. That is it the same attorney bringing the same types of claims against the same company? It would be unusual for someone perhaps to have 12 consecutive, represent people in 12 consecutive jewelry loss, mysterious disappearance claims, and that might draw some scrutiny from the company as well. Another thing would be attempts to set up the insurance company, and I'm going to give a very quick example of that. In one situation that I am aware of, the insured claimed that their automobile was stolen. And now would be natural for them to have two sets of keys, and that the thief somehow took the vehicle without using and getting one of those sets of keys. The investigators asked for those repeatedly, and finally an examination under oath was scheduled, and on the eve of the examination under oath, an envelope arrived at the investigator's office. Now, inside the envelope was one set of keys, and that's what was reported. So during the examination under oath, the insured was asked a hypothetical question on that. The hypothetical question being, you recently sent an envelope to the investigators, and if the investigators followed the company's instructions and have not as yet opened that envelope, what will we find when we open it? Will there be one set of keys, two sets of keys, something else? And the shock on that person was visible, and eventually they withdrew the claim and did not press it, because they thought they had set it up where the company would be liable to say that only one set of keys was received, and they could say, no, we sent two. So that's an attempted setup. It's one small example for you. Other things that might come out would be, or cause interest, is if you demonstrate an knowledge of words or terms peculiar to the insurance industry or under the policy. It might be a word such as reservation of rights, I don't know, could be many, many things. However, this may alert them or cause them to feel that you have some specialized knowledge and you're savvy about making claims. And this is how many of them think. Not all, but many. And of course, they would look at material inconsistencies from previous statements, which is why you should always try to get any previous statement or recorded interview that you've given before you give your examination under oath. Now, there may be surveillance. Somebody's claiming a leg injury, for example. They may actually, knowing that you're going to be coming to the examination under oath, have surveillance and take pictures of you on your way into the building and when you leave the building, to see how your gait is. If you are in the building saying that you can't walk and you come in with crutches, and then someone tosses them away outside the building or just puts them under their arm and walks along, that would be a significant thing. So there is the possibility of surveillance at many times. At the end of it all, however, I'm just going to end up with this. This topic is an extensive subject. The companies will usually reserve their rights to come back and ask further questions if the investigation calls for that. And the policies generally allow for that. Now, in turn, the insured should always ask for the right to present corrections and any additional information that comes to the insured's knowledge after the examination under oath. So these are ways of keeping the door open in case you forgot something, because that happens quite often to all of us when we're trying to recollect events that are extensive or things of that nature. So I hope that this little series on examinations under oath gives you some knowledge and some thoughts about how these examinations, which are very important to claims, proceed, and things that you may want to be aware of. Again, the lawyers in the Legal Strike Force are here to help you, whether it be in the New England area or now down in Pennsylvania with Michael McCary. And you can look us up certainly on the website, www.lawyers-online.us. Michael's biography is there. Mine is there. Our other attorneys and people are there. Thank you very much, and hope to see you again soon here on the Legal Strike Force YouTube channel and Facebook page. Thank you.